Good morning, everyone. This is Kristen O'Neill with the Committee on Open Government. Get started in just a moment. It seems like we have a kind of a small gathering today in terms of how many people have logged on for this program. So what I may try to do, just a second. Okay, it's 10:02. There might be a couple more people logging on as we get going. Given our small number, what I am going to try to do is take questions as we go along instead of what I normally do during these programs, which is do questions during the chat feature. I think at this point, I think we only have like 6 or 7 people logged on to the program. So it may be beneficial to let everybody sort of just ask their questions as as they come up during the presentation. So what I will do, sorry, I just want to make sure, being a one-woman show, I want to be able to try to make sure I'm paying attention to where I need to pay attention to. One of you all, give everybody, hopefully has the opportunity to raise their hands when they have a question. So if you have a question as we go along, you can use the raise hand feature, and and I can unmute you in that moment and can take questions. So as I said, my name is Kristen O'Neill. I'm with the New York State Committee on Open Government. Today we're doing a program on the Freedom of Information Law. It's sort of a refresher on the requirements of the Freedom of Information Law and any updates that have come up in the past year or so. Phone number, this is the office phone number, 518-474-2518. It is, we're a small office. There's 4 attorneys, including the executive director and myself, the assistant director. And then we have a senior attorney and Excelsior fellow. So 4 attorneys plus our 1 administrative assistant. And so we're a small office. If you get voicemail when you call, please don't hesitate to leave a voicemail because the phones can get busy sometimes, but we will get back to you as quickly as possible. Our website is www.opengovernment.ny.gov. Freedom of Information Law is codified in Article 6 of New York State Public Officers Law. So sometimes you'll see a reference to Public Officers Law in Article 6 or Public Officers Law Section 87 or 89. Those are the statutory references to sections of the Freedom of Information Law. We always keep an up-to-date version of the Freedom of Information Law and the Open Meetings Law on our website. So if you go to opengovernment.ny.gov, we have a menu bar at the top of the screen, and you can find a copy of the statute. In fact, I'm just going to take a moment here. I'm going to stop sharing here. I'm going to go to my Okay, right now I'm sharing a copy of our website. Everyone should be able to see what I see on the website. This is our homepage. We put important information, anything, any recent updates, any recent publications. We put that right here on our website. The top of the screen, you'll see these drop-down menus with information about the Freedom of Information Law, the Open Meetings Law, about any meetings and events that we might be having. We have our About Us page and our Contact Us page. So here with the Freedom of Information Law, if you click here, it'll bring you down to linkable section. Unfortunately, you have to click more times than I would prefer, but you can get there eventually. And a copy of the Freedom of Information Law is right here. Same is true of the Open Meetings Law. In addition, you can find on our website advisory opinions, and the advisory opinions are indexed by key phrase, alphabetically by key phrase. So if you're looking for advisory opinions regarding fees, for examples, you can scroll down and you can find advisory opinions relating to FERPA. You can find them about fees, all sorts of topics for review. It's also searchable by keyword. So if you have a key phrase that you're thinking of, you can just type it into the box and hit search, and hopefully you'll get some results that are helpful to you. Finally, we also have a case law summary. We have our regulations. So a lot of good, helpful information. We have a publication called Your Right to Know, and available in a couple different languages, our annual report. Lots of helpful information on our website. So it's always a good place to start if you're looking for guidance before you give us a call. All right, so now I'm going to move away from that and go back to my PowerPoint. The original Freedom of Information Law was enacted in 1974. It's fairly limited in scope. The original version only gave the public access to 9 categories of records. And if you couldn't find what you were looking for in those 9 categories of records, you were essentially out of luck. It wasn't a very popular version of the statute, so it was repealed and replaced with the current version in 1978 that is based on a presumption of access. The current version of the statute, you start with the assumption that all government records are subject to FOIL disclosure, and then you can review. As an agency, they have the right to review the records to determine whether the record or any portion of the record fits into one of the permissible grounds for denial. Who is covered by FOIL? FOIL governs access to agency records, and the term agency is defined as any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state or for any one or more municipalities thereof, except the judiciary or the state legislature. So the courts are not subject to the Freedom of Information Law. It doesn't mean that you can't get access to court records. It's not just not through the Freedom of Information Law, it's through judiciary law. And the state legislature is subject to FOIL in a very limited fashion. They're not considered agencies that are where access is based on that presumption of access. The Freedom of Information Law has list of the types of record, just similar to that 1974 version of the statute, that's still applicable to the state legislature. There's a list of the types of records you can get from the state legislature, and if you don't see it on that list, FOIL does not mandate disclosure. Records access officer. Every agency is supposed to have somebody who is responsible for coordinating agency's response to FOIL requests, and that person is referred to as a records access officer. The governing body of a public corporation or the head of an executive agency or governing body shall be responsible for ensuring compliance with FOIL regulations. So everybody, all government employees, all the officials, particularly the head of an agency or the governing body of the agency is responsible for ensuring compliance with the Freedom of Information Law, not just the records access officer. The records access officer might be the point person, the person that's responsible for coordinating the agency's response, but everybody has legal responsibilities in terms of compliance. So that person is supposed to be designated by name or by specific job title. The information relating to the records access officer should include a business address. And now 20 years later, this should just be a no-brainer that there should be an email address for contacting the records access officer. Term record. For the purposes of Freedom of Information Law, the term record is defined very broadly. It means any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever, including but not limited to reports, statements, examinations, memoranda. I could go on, but I'll stop there. Basically, it's any information in any physical form whatsoever. Definition is very, very broad. Under the Freedom of Information Law, an agency, though, is not required to create records in order to respond to a FOIL request. An agency is not required to answer questions. The FOIL governs access to existing records that exist at the time the FOIL request is made. This does not mean that an agency is not required to make copies of existing records or to convert the records to a preferred format if possible. So for example, if you have records that are only in paper form and an applicant has asked you to scan them and email them, and you have the ability as a government agency to do that, you are required to do it. There are 3 exceptions to the rule that you're not required to create a record as an agency. The first exception is every agency is required to maintain a record of how each member of a public body that's housed by that agency voted during a meeting that's subject to the open meetings law. So maybe wondering, well, why is this here in FOIL and not in the open meetings law? And I believe my understanding is because this predates the open meetings law. The open meetings law requires public bodies to prepare minutes that reflect the results of a vote, but it doesn't actually require that the minutes reflect how each member voted. However, the Freedom of Information Law contains a provision that states that every agency must maintain a record of how each member of a public body voted. So generally, people just include that agencies and public bodies will include that information in their meeting minutes because it's simpler, obviously, than having 2 separate records. The second exception is that every agency is required by law to maintain and make available a list of the names, public office addresses, so not home addresses, public office addresses, titles, and salaries of all of its employees and officers. And the third exception is every agency is required by law to maintain a reasonably detailed subject matter list. These are the types of records that an agency maintains, regardless of whether they're available under the Freedom of Information Law or not. I'll talk a little bit more about the distinction between creating new records and preparing copies of existing records. The law states that an agency shall provide records on the medium requested by a person if the agency can reasonably make such copies or have the copy made by engaging in outside professional service. So example, again, if you have records in paper form and the person wants them scanned into electronic format and you have the ability to do that, as an agency, you must. If a request is made for copies of blueprints or maps and you don't have the ability as an agency to to make those copies in-house, you would have an obligation to send them out to an outside professional service, assuming the individual who's making the request is willing to pay the associated fee, which we'll talk about a little bit more later in the presentation. Another thing to remember is this provision would require, if an applicant is requesting a copy of a record in its original format, such as a Word document, an Excel document, perhaps an Access database. If the request is made for the records in the format that they originated in, an agency must provide it in that requested format. Some agencies prefer to convert things to PDF, for example, prior to disclosing the copy of the record. If the agency has the ability to provide a copy in the original format, and that's the formats that's being requested, the agency is obligated by statute to provide it in the requested format. When an agency has the ability to retrieve or extract a record or data maintained in a computer storage system with reasonable effort, it shall be required to do so. Again, this is another statutory obligation, and it shall not be deemed to be the preparation or creation of a new record. If an agency maintains a database and that database can be queried to produce the data set, the records that are being requested, the agency has an obligation to produce that record, regardless of whether or not it's a record or a report that's prepared and produced in the normal course of business. Just checking my email, I wanted to make sure someone was not raising concerns about being able to get through. Okay. When an individual member of the public makes a FOIL request, they have an obligation to reasonably describe the records sought. And the first thing that an agency is going to look to in determining whether the agency has reasonably described the records sought is, can the agency locate or retrieve the record with reasonable effort? Are the records maintained in a manner, is the filing system, does it allow the record to be located with reasonable effort? And I'll give you an example here. If you have my PowerPoint up, you'll see a picture of a filing cabinet. This is essentially how the Committee on Open Government files paper copies of FOIL appeals that it receives. Freedom of Information law requires every agency to provide the Committee on Open Government with a copy of all appeals that it receives and their appeal determinations. So we do tend to, in the past several years, we've started to receive these more and more via email, and we maintain them electronically, but agencies still do provide us with paper copies. And what would happen is we would receive them by mail, we would review them, take a look at them, see if there's anything we needed to do, bring to anyone's attention about concerns we had with the appeals or the appeal determinations. But then they would essentially get filed by date. You'd have a filing system that's, a year there, you'll see, and we would have January, February, March. Every day we would put the paper copies of appeals that we received in the mail in the filing cabinet based on the date they were received. So if someone made a Freedom of Information law request to the Committee on Open Government for copies of all appeal determinations received, for example, by the City of Albany over a period of time, we would not have had any ability up until the past couple of years to respond to that request with reasonable effort, because that's not how we filed our records. We had no log system. We had no electronic logging system or storage system that allowed us to locate appeals by agency. In the past several years, we've started logging our appeals and we identify the agency that issued the appeal determination. We And so if someone made that same request today, we'd be able to respond to that without having to dig through perhaps thousands of appeal determinations to determine which ones were responsive. Another aspect is just a much simpler aspect of this issue is when someone makes a request for records, the agency is going to look at it and say, do I understand what this person is asking for? Do I understand the request? Are they using terminology that I'm familiar with so that I can locate the records that this person is looking for? If not, they should go back to the applicant and engage in a conversation to try to understand what the person is seeking. Time limits. Every agency, upon receipt of a Freedom of Information Law request, is required to comply with certain time limits in terms of response. The first time limit is 5 business days. The agency must do something within that first 5 business days. It must either respond to the request by providing access to the records sought, particularly if it's a simple request, something, a FOIL request might be made to a town clerk, records access officer for a copy of the meeting minutes from last month's town board meeting. That's a pretty easy request. It should be able to be responded to very quickly within that first 5 business days. The second option might be to deny a request within the first 5 business days because the person is asking for something that is either confidential by statute or, like, for example, I used to work for the Office of Mental Health. Sometimes we would get Freedom of Information Law requests for an individual's psychiatric records. Well, that's an easy response for me because those were confidential by statute, and the Freedom of Information Law was not the appropriate avenue for trying to obtain those records. So that would be something that I would respond to very quickly without having to make anyone wait. Third option would be to say, we don't have the records you're seeking. We do not possess the records sought, or we cannot locate them after a diligent search, perhaps because the person who made the request is just making them to the wrong unit of government. Maybe someone made a FOIL request to town government for records that are actually maintained by the county government. So that might be a reason why the agency would respond by stating we do not possess the records sought. Fourth option is available when the request is voluminous or complicated, or simply that the request itself might be fairly simple, but the agency is dealing with a large number of FOIL requests. So even though the person who's making the request might be making a simple request, unfortunately, they might be having to get in line behind dozens of other people that are also making simple requests. And it's going to take more than 5 business days for the agency to turn that request around. So within that first 5 business days, the agency is going to be obligated to acknowledge the request and state they need more time. I apologize. Sometimes I take a break because I just want to check on something from a tech standpoint. And sometimes I worry I'm missing something, but I think we're okay right now. So that acknowledgement must include a date by which the agency plans to respond. Generally, rule of thumb is that an agency should be able to respond within 20 business days of the acknowledgement. The law allows for additional time beyond that 20 business days, but only if the circumstances surrounding the request authorize it. If the amount of additional time is reasonable given the circumstances of the request. Couple of reasons why an agency might need more than 20 business days to respond to a request is because it's a very large request for numerous records. Maybe it's a request that's going to require extensive legal review to determine rights of access. Again, it may simply be that a particular agency deals with quite a lot of FOIL requests. And while your particular FOIL request might not be particularly complex or voluminous, again, it might be in line behind several other requests that are complicated and voluminous, or simply it's just a sheer volume issue. But whatever the case may be, the agency has an obligation to provide a reason for the delay and a date certain by which they plan to respond. Agencies should not be issuing repeated extensions month after month at the time, either at the time of acknowledgement or at some point prior to the first 20 business days. Agency should evaluate how long it's going to take to provide its response and provide a date certain instead of bumping it out month after month after month. If an agency issues a denial of access, the applicant has 30 calendar days to appeal that denial. And if an agency receives an appeal, they have 10 business days to respond to the appeal. Email requests. This is somewhat dated, but I like to point it out anyway. There was an amendment to the open meetings law that specifically states that if an agency is able, it must accept a request by email. I can't imagine that there's any government agency in the state of New York that does not have the ability to accept requests by email. So this should be, again, a no-brainer. An agency cannot require a requester to use its form, but can require that a request be made in writing. Unless there are personal privacy concerns relating to the records, an applicant for records should be permitted to remain anonymous. Appeals. There are two types of situation that gives rise to the right to file an administrative appeal. One is an express or an affirmative denial of access, and that's when the record is possessed by an agency but is being withheld in whole or in part. The second situation that gives rise to the right to file an administrative appeal is a constructive denial of access. Just want to point out that these aren't terms that you're necessarily going to find in the statute, but the situations are described in the statute. You won't see the term constructive denial. It's just a term of art that has been around probably as long as the Freedom of Information Law has been around. So a constructive denial of access is when an agency fails to respond to the request within the time limit set forth in statute. Perhaps they failed to acknowledge within 5 business days, or they acknowledged but failed to respond within 20 business days from the acknowledgement. Another situation that gives rise to the right to file an administrative appeal is when an agency states that they need more than 20 business days to respond to the appeal. They give a date, and the person who made the request does not believe that the date is reasonable given the circumstances. So essentially what they can do is challenge the amount of time that the records access officer has advised them it's going to take to respond to the request. That's what they're appealing. So that's another option for filing an appeal. We have model language for both these types of appeals on the Committee on Open Government's website, both the express denial and the constructive denial. So if you're an applicant for records and are looking for guidance about how to file that appeal, we do have model language on our website. Permissible grounds for denial. So as I stated at the beginning of the program, the Freedom of Information Law is based on a presumption of access. All government records are public unless an agency can assert one of the statutory permissible grounds for denial. If you can't find a reason in statute, if you can't find statutory language to rely on in order to deny access to a record or a portion of a record, then the record must be disclosed. And included in my PowerPoint, which by the way is available on the Committee on Open Government's website. At the end of the program, I can go back to the website and show you where to find these PowerPoints. In addition, this program is being recorded and will be available on our website as well. So if you want to share that information with colleagues that maybe wanted to do this program, but were not able to, programs being recorded. Previous programs have been recorded. They're all available on our YouTube page, and I can tell you where to find that too towards the end of the program. So we're not going to talk about every statutory ground, but I am going to talk a little bit about some of the more commonly asserted grounds for denial. The first is when a record is exempt by state or federal statute. Can't be a local law, can't be a regulation. It has to be a state or a federal statute that makes a record confidential, that exempts that record from disclosure under the Freedom of Information Law. Some examples, some common examples are attorney-client communications. If you have a municipal government, town board, town supervisor communicating, requesting legal advice from the town attorney, and the town attorney responds by providing legal advice, that's a communication that's covered by the attorney-client privilege and can be exempt from disclosure pursuant to this provision of FOIL. If you make a Freedom of Information Law request to a school district or a CUNY or a SUNY or a community college, a public learning institution, those student education records are exempt from FOIL disclosure pursuant to federal statutes. The Family Educational Rights and Privacy Act, the federal law that makes student education records confidential by federal law. So I cannot make a request for, make a FOIL request for my neighbor's kids' education records. Mental health records, as I mentioned, I used to work for the Office of Mental Health. I was their records access officer. And sometimes people would make FOIL requests for psychiatric records. Those are exempt from disclosure, not only by federal HIPAA privacy regulations, but by New York State mental hygiene law. Some lesser known privacy considerations are autopsy records. New York State county law makes autopsy records confidential. New York State county law makes county operated E911 records, including recordings and transcripts of 911 calls, confidential. So in general, if it's a county operated 911 system, you can't make a FOIL request, or you can make a FOIL request, but it's likely going to be denied for a recording or a transcript of a 911 call, even if you were the person who made the call. Personal Privacy Protection Law, Public Officers Law, Section 96A, makes social security numbers confidential. So if an agency has a record that contains anyone's social security number, they should be redacting that social security number from the document before disclosing the document. A second commonly asserted ground for denial of access is when disclosure would constitute an unwarranted invasion of personal privacy. Some examples of that would be you have a job opening, a public employment job opening, and 10 people apply for the position, but only one person is hired. The employment applications and names of the individuals who applied for that position could be withheld on the ground that disclosure would constitute an unwarranted invasion of personal privacy. Anyone's home telephone numbers or personal cell phone numbers, including whether you're a member of the public or whether you're a public employee, home telephone numbers and personal cell phone numbers can be withheld as an unwarranted invasion of personal privacy. Medical information contained by an agency, even if the agency is not a healthcare provider. So for example, if you're a public employer and you contain medical information, maybe about an FMLA leave for a particular employee, and that medical information is contained in the person's personnel file, disclosure of that medical information would likely constitute an unwarranted invasion of personal privacy, and the agency would have the ability to withhold. Backing up just a little bit here is what I want to point out is, except for circumstances where there's a separate state or federal statute that governs disclosure, all of these grounds for denial, the unwarranted invasion of personal privacy, interagency material, law enforcement, all of those grounds for denial, other than the grounds that a record is confidential by state or federal statute, are permissive. So what I mean by that is an agency can assert that disclosure would constitute an unwarranted invasion of personal privacy, but it's not required to assert. Certainly, agencies should be consistent about when they assert the grounds for denial. so they're not playing favorites, for example. You want to be consistent as an agency when you're asserting these grounds for denial, but they are permissive. Just means that they can deny access on these grounds, not that they're required to deny on these grounds. Public employees' home addresses can be withheld as an unwarranted invasion of personal privacy. List of names and addresses of natural persons, if that information would be used for solicitation or fundraising purposes, and mugshots. So again, if a law enforcement agency, there's nothing prohibiting them from disclosing a mugshot if it's needed for a specific law enforcement function. But if someone makes a FOIL request for a copy of a mugshot, maybe their neighbor's mugshot, the agency could deny on the ground that disclosure would constitute an unwarranted invasion of personal privacy. Again, here I like to point out that public employees enjoy a lesser degree of privacy than other members of the public. There's certain information about public employees that is going to be publicly available under the Freedom of Information Law, whereas that same information might not be available about an individual who works in private practice, private service. For example, our salaries, as we've already mentioned, public employees' salaries or public information, our public employment history. If, like, for example, I've worked for the state for almost 22 years now. If you wanted to find out everywhere I've worked and all my titles over the past 22 years, that's information that's publicly available. Our licenses, what type of licenses we have, our degrees, particularly if that license and degree is a necessary for us to obtain the job that we have, all of that would be public information. Law enforcement records. Whether a law enforcement record must be disclosed or not, it's going to be based on a two-part test. The first being, was the record in fact compiled for law enforcement purposes? And it's a two-part test, and you have to meet both part of the test in order for an agency to withhold a record. The first was the record compiled for law and purpose. So what an agency needs to do is determine whether the record is being used for a law enforcement purpose at the time the request is made. Not necessarily what the original purpose of the record was. This is based on a court case from, now we're going on, 4 or 5 years ago, where a FOIL request was made for copies of time and attendance records for an individual who worked for the New York State Executive Chamber for the governor's office at the time. And the governor's office took the position that those were records that had been compiled for a law enforcement purpose because at the time of the request, those time and attendance records had been turned over to the United States Department of Justice because the DOJ was conducting a federal investigation. So even though those timesheets, perhaps the time and attendance records, are just regular business records, they're not law enforcement records, they're just administrative day-to-day business records. However, at the time the request was made, they had been compiled for a law enforcement purpose. The law enforcement purpose can also be for civil law enforcement. There is also 2017 case law that's because the New York State Education Department was conducting a civil law enforcement function, that the records that they had compiled for a particular purpose could be withheld as long as they met the second part of the test, which we will talk about. Second part of the test is that the disclosure of the records would cause one of the harms envisioned by the statute. So one, they have to be compiled for law enforcement purposes, and two, disclosure would have to cause a harm. For example, would disclosure interfere with a law enforcement investigation or judicial proceeding? Would disclosure deprive a person of the right to a fair trial or impartial adjudication? Would disclosure identify a confidential source or disclose confidential information relating to a criminal investigation? So that provision is specifically relating to criminal investigations. And 4, would disclosure reveal non-routine criminal investigative techniques? For example, would disclosure provide information to a potential lawbreaker that would allow that individual to evade law enforcement detection. So that's the law enforcement exception. A third commonly asserted ground for denial are intra-agency and interagency material. That those are documents that are maintained either solely within a single agency or only shared between and among multiple New York State government agencies. And when I say New York State, I just mean located within New York State. It could be a town government communicating with a county government, or a town government communicating with a New York State agency, or any different type of state agency. So it all could be intra-agency, internal within a single agency, or interagency, where it's between or among multiple agencies, as the term is defined by FOIL. And the purpose of this is to protect the deliberative process, to allow government employees to engage in a deliberative process, sort of without fear that everything that they do, all the opinions and recommendations that they offer are going to be disclosed to the public, because that would chill the deliberative process if that were the case. What is required to be disclosed is statistical or factual tabulations or data that are maintained with that interagency material, instructions to staff that affect the public. For example, when COVID first became an issue and government agencies were starting to move from working in person in offices to telecommuting, working from home, there had to be instructions given to staff regarding that process. So that might be an example of instructions to staff that affected the public. The public needed to know what the public employees at their local government were being told to do in terms of should they be working from the office? Should they be working from home? You know, what is there any sort of mix? That's the type of information that would be instructions to staff that affect the public. Final agency policies or determinations. So for example, if there was an investigation into a public employee disciplinary matter, the final determination issued by the person who has the authority to make that final determination, that might be sent to the person who engaged in the misconduct, that would be information that would be required to be disclosed. External audits, including audits conducted by the Office of the State Comptroller, even though that might be an interagency document, it fits into one of the exceptions, so external audits are required to be disclosed. Certification. There are two types of certification requirements that an agency might need to provide. What this law states is, upon payment of or offer to pay the fee prescribed therefor, an entity, meaning the agency, shall provide a copy of the record and certify to the correctness of the copy if requested, or, as the case may be, shall certify that it does not have possession of the record, or the record cannot be found after a diligent search. I'll note that when an agency states that it does not possess the record sought, that's not a denial of access that gives rise to the right to an administrative appeal. So if you as an applicant receive a response from an agency that it does not possess the record sought, that's not a denial of access. It is, it's simply a statement that the agency does not have the record sought. You can request, by law, you have the right to request and receive a certification from the agency. And there's no sort of legal standard for what that certification must include. My recommendation to agencies is to model the language of the statute and to state that I certify, I include your name, include the name of the agency that you're representing, certify that we do not possess the records sought. I usually recommend that the agency include a brief description of the records that were requested, just to be so that all parties concerned can be sure that we're talking about the correct records. But again, that's not a denial of access. That's simply a statement that the agency does not have what you're looking for. The second type of certification is the right of the applicant to be sure that the copy of the record that they received is a correct copy of the original that is maintained by the office. So this is not a certification as to the accuracy of the information contained in the record. The agency isn't promising you that the information in the record is accurate. It's simply certifying that what the agency gave the applicant is the same as what they have in the office. It looked, except unless there's redactions, which should have been identified, but the copy that was given to the applicant should look exactly like the copy that's maintained or the original that's maintained within the agency. That's what that certification is for. Right to appeal. When denied access to a record or any portion of a record, and that means even a simple redaction within a document, when denied access to a record or any portion of a record, an applicant has 30 calendar days to appeal. And that information about how to appeal must be included in the denial letter. So an agency must state in the denial letter that the applicant has 30 calendar days to appeal and must give directions about how to file that appeal. The FOIL appeals officer is either the head or governing body of an agency or the person or persons designated by the head or governing body. Our regulations state that the FOIL appeals officer cannot be the same person as the records access officer. Within 10 business days, FOIL appeals officer must either provide the records sought or fully explain the reasons for further denial. Sometimes it's a combination of both those things. The law does not contemplate a remand back to the records access officer. It is the responsibility of the appeals officer to review the records at the appeal level. An agency is required to send a copy of the appeal and the appeal determination to the Committee on Open Government. Fees. Fees can be very confusing for some agencies. What's important to remember is that there are two fee structures, and these fee structures cannot be combined. The first fee structure is 25 cents per photocopy for copies up to 9 by 14 inches. So if someone would like photocopies of a record and it's a standard piece of paper, you charge them 25 cents per photocopy. That's it. End of story. Done. No other fees are permissible. Specifically, you cannot charge, as an agency, cannot charge for the search time it took to locate the record or the time it took to review the record to determine rights of access. The second fee structure is for either records that are larger than 9 by 14 inches or records in some other format other than photocopies. So what the law states is that an agency may charge the actual cost of reproduction for all other records. And then the law states what an agency is allowed to consider when determining the actual cost of reproduction. One consideration is the salary of the lowest paid employee capable of preparing a copy of the record, but only if it takes at least 2 hours. So let's use scanning as a nice simple example. Someone would like a copy of a record, but the original is only in paper format, but the agency has a multifunction photocopier / scanner. And the person who made the request says, I would like you to scan the records into an electronic format and email them to me. If the agency has the ability to do that, it must. And if it takes only, say, 10 or 15 minutes to scan those records, then no fee is going to be authorized by statute. If the records are available in their entirety, don't need to be redacted, then and it only takes about 15 minutes to scan those records, then there's not going to be a fee that's going to be authorized by statute to be passed along to the requester. On the other hand, if it takes more than 2 hours to scan those records, then the agency is going to be allowed to charge the salary of the lowest paid employee capable of preparing the copies multiplied by the number of hours it took to make those copies. If an agency, in terms of scanning generally, because this comes up frequently, I'll note that if an agency does not have the ability to redact records electronically, but must first photocopy the records in order to make the redactions prior to scanning them, the agency is going to be allowed to charge the 25 cents per photocopy in that instance. Same is going to be true for inspection. Individuals, when making a FOIL request, have the right to inspect or get copies of a record. However, if the records are not available in their entirety, the applicant is not going to have the right to inspect. The applicant only has the right to inspect records that are available in their original format in their entirety. If they need to be redacted first, the agency is going to be allowed to charge that 25 cents per photocopy or whatever the fee may be authorized by statute if it's in some other format other than photocopying. If you need to, if the records, the electronic records are so large that they can't be emailed, the agency can charge the cost of an electronic storage device like a DVD or a thumb drive. If an agency has to send a record out to a third-party vendor, such as, if it's, maps, blueprints, audio, video, whatever the fee charged by the third-party vendor can be passed along to the applicant. Again, though, as a reminder, the law specifically states an agency cannot charge for the time it takes to search for the record. It cannot charge for the time it takes to review the records to determine rights of access. Those are not reimbursable costs. Let's see if there's anything else I want to remind myself here. That's it. In December last month, Governor Hochul signed into law a provision. It's a little bit of an odd provision because, to be honest, if all agencies are doing what they're required to do by statute in terms of record retention, this really shouldn't be, the agency should have already been doing this. But I guess it's just clarifying by statute that an agency must do this. But as I said, if agencies were really doing what they were supposed to do in terms of record retention, then this wouldn't be an issue. But what the law says is where an identical record has been prepared for a previous request within the past 6 months and an electronic copy is available, an agency shall not charge a fee. And then it says if more than one request is made for an identical record before any such request has been fulfilled, any fees charged by the agency under the subparagraph should be apportioned equally among the requesters. So I guess that second part might be new. But in terms of that first part, let's just say someone makes a FOIL request for copies of a large amount of records that required scanning. It took 2 or more hours for municipal staff to scan those records, and the first applicant was charged, I don't know, $100 for the time it took to scan those records. Under the New York State Archives record retention and disposition schedule, an agency is required to retain those records that were provided to the applicant for a minimum of 6 months. So at the time, if within that 6-month period, a second applicant makes a request for those same records, they already exist in electronic format. So an agency shouldn't be able to charge again for making the copies because they already exist in electronic format. There shouldn't be any work involved in preparing a second copy. This second part is, say someone makes a request on day 1, the agency starts working on it, and a week later, someone else makes the same request. My understanding is what the statute is saying is whatever the fee is that you would have charged person number 1, you should split it among however many people make that same request. It was a little bit of an odd amendment, but that came about last month. Enforcement, just as a reminder to those that are not aware, the Committee on Open Government does not have enforcement authority. We can provide advice and legal opinions regarding the Freedom of Information Law and the Open Meetings Law. We don't have the authority to investigate complaints or to compel an agency or a public body to take certain action. Only the courts, through the initiation of a civil practice law and rules, Article 78 proceeding in state Supreme Court, have enforcement authority. If an individual brings an Article 78 proceeding, attorney's fees and other reasonable litigation costs can be awarded to the petitioner, and they are mandatory on the part of a judge when the petitioner has substantially prevailed and the court finds that the agency had no reasonable basis for denying access. Attorney's fees are discretionary on the part of the judge when the requester has substantially prevailed and the agency failed to respond to request or appeal within the statutory time frame. Questions? So everyone's aware, anyone is welcome to contact the Committee on Open Government with the questions regarding the Freedom of Information Law and the Open Meetings Law. Our phone number, again, that I provided at the beginning, it's 518-474-2518. The best way to email our office is to email our acronym, which is COOG, COOG@dos.ny.gov. It's a joint email address that all of the staff in our office, all 5 of us, have access to. So essentially, the first attorney in the office that has the ability to get back to you and respond to your inquiry, it's just a much quicker way than perhaps emailing any one of us individually. That way, it is just processed more quickly if you use that joint email address. If people have questions, they're welcome to raise their hands. I'm just going to go back and show you. Let's see, I'm going to stop this. I'm going to show you where you can find the recordings. I'm going to go back to my home page. All right, so back here, I'm on the home page, the Committee on Open Government's website. And if you scroll down the page a little bit, you're going to see this section that says, I would like to. And a couple helpful things here is we have sample language for making FOIL requests. We have sample language for appealing denials. We have guidance documents about time limits. We have contact information for when you want to request an advisory opinion. But this is the box that I was mentioning earlier. If you click on this box, you're going to see that there's a link to our YouTube page. So the YouTube page has quite a few copies of the trainings that I've been doing for the past couple of years, these virtual monthly information sessions. You know, to a large extent, one is going to look exactly like another. However, of course, if there's been any updates to the statute, I'm going to address those in the more recent. So if you are looking for a recording or you want to share a recording with someone of a program, it's probably just best to pick the most recent program that's available on our YouTube page to share or to look to review yourself. And I will get today's program up, hopefully within the week. I can get this get the recording of this program up on our YouTube page. In addition, we have PDF copies of my PowerPoints are available, both FOIL and Open Meetings Law. So I just wanted to share that. I'm going to stop sharing. And now I'm just gonna apologize, I look kind of scruffy today. Looks like a couple of people put questions in the chat function, but I've got somebody, Christopher. I'm going to unmute you. Christopher, let's see, unmute. Go ahead, Christopher. What's your question? I'm not sure if Christopher can hear me, but I am not hearing him. Let me just make sure my volume is up. Well, hold on, I'll unmute you again. All right, Christopher, I just want to give you a couple more seconds if you want to ask a question. If not, you're also welcome to put it in the chat function. If for some reason we're having technical difficulties and you're not able to ask verbally. Okay. Unfortunately, either we're having some tech questions or Chris has decided to leave us. I don't know, but all right. I'm gonna go back. Oh, I think Chris, he did ask a question earlier via chat, so maybe that I'll just ask that one. Question was, are resumes or letters of recommendations considered employment applications? I would characterize that as employment application information. So resume, I would equate to an employment application. Some courts have held that if you're able to redact a resume or employment application sufficiently to protect the identity of the person who's applying for the position, then you should do so if a FOIL request is made for those applications or resumes. But it's the same sort of concept of resumes provided or employment applications for people that were not chosen to fill a position. If you cannot redact sufficiently to protect their identity, they can be withheld on personal privacy grounds. But a lot of times, like for example, I'm the only person in the world that has served as the assistant director of the Committee on Open Government for the past 7 or 8 years. So redacting my name and address is not going to be sufficient to protect my privacy. That's just one example. And letters of recommendation, in my opinion, can be withheld on personal privacy grounds. Let's see. Jeffrey has raised their hand. Jeffrey, can you hear me?
Yes, I can. Can you hear me?
Great. Yes, now I can hear you. So go ahead.
All right. So in your PowerPoint, you indicated that there were classes of records that an agency is required to maintain. I was wondering, are these classes of records located in the public officers law, in the Freedom of Information law?
You mean the subject matter list?
Yes.
And yes, it is section 87. It's terrible when I don't know these things off my top of my head.
It's fine. It's fine if you don't know.
Yeah, no, it's
in there.
It's a specific list within the statute of those 3 items. Yes.
Okay. All right. Excellent. Great. Thank you.
Okay, Lori, someone is asking, are public housing authorities considered an agency under FOIL? My recollection, I just don't want you to hold me to this, but my recollection is that housing authorities are public corporations or public benefit corporations that are required to comply with FOIL and the Open Meetings Law. When a request is made for existing documents and the request is made that the documents be provided in machine readable format, if an agency has, what it comes down to is if an agency has the ability to provide a copy of a record in the format that is requested, then yes, it should provide it in that format. I've got another raised hand, Kristen W. Let's see. Kristen, can you hear me?
Hi.
Great.
I can hear you. Can you hear me?
Yes, great.
I just had a question about, let's say, voluminous requests, where I know that you can't deny it just because it is voluminous. So I'm going to, for a hypothetical, say a FOIL request is made of a school district for all emails sent within a 5-month period between their director of special ed and anyone else. Those are easily found. You know, you just would do a keyword search for this person. Yeah. However, that could be 6,000 emails that could contain student information that then have to be looked at. So it seems from what I've read in all of the advisory opinions that there is no way to, you can't charge for the time spent redacting, and there you can't deny the request because it's voluminous. With the electronic records becoming so much more prevalent and so much more easily accessible, do you see any move to kind of address these kinds of very, very burdensome requests?
I think in the situation you describe, I have something that helps a little bit. There is an old case law called Fisher and Fisher v. Davison that actually had to do with records in a filing cabinet, but has been applicable to, and we have advisory opinions on our website that reference this case, where the situation exactly as you described, where you've got thousands of email communications that all need to be reviewed to determine rights of access, particularly when you're dealing with something that may be confidential by federal statute, and it's not just a permissive redaction, but required redaction. I apologize that there's an echo. I've got two screens open. In our view, you could deny the request on the grounds that the request goes beyond the scope of what FOIL intended. You want to shoot me an email? I can try to share with you some of those opinions that reflect that.
Great. Thank you so much. I appreciate that.
Great. All right, I think we've got Chris back. Oh. Sorry. Chris.
Hi,
Hi.
can you hear me?
I can.
I had to unplug and unplug back my microphone.
Okay.
Back to my original, you did answer me on the resume and employment applications. Is the resume, if someone submits a resume instead of an employment application, would you be able to foil that? If you, in your original FOIL, request redactions for the name and address and private information of the person such that you can review their qualifications?
Are we talking about people that were hired to
Well,
fill a public employment, or are we talking about people that just applied?
just applied.
I mean, the same, I think that was the point I was trying to make, is that really it doesn't matter whether it's in an application or whether it's a resume. The same concept is going to apply.
Okay. Well, there's really, like, for example, like there are certain jobs you apply for, like I think we spoke about it or started in your presentation, whereby you have to have, let's say, a bachelor's degree, and you put on your resume you have a bachelor's degree and you're applying for a position, and then later we find out you don't have a bachelor's degree, and some applicants who actually had the credentials were disqualified, not because, for one reason or another, but the person awarded the position said he had credentials that he didn't have. Did you know where to check on that I'm aware of, unless you're trusting that into the entity itself? So I guess the FOIL has its limitations on being able to check the checks and balances of an own government, I guess. You'd have to find another vehicle, I guess.
Right. I mean, certainly FOIL does have its limitations.
Okay. All right. And then the other follow-up question I have, and I have noticed this, and I think people listening will have experienced the same thing, whereby if you go to an entity and FOIL for something, the FOIL officer typically will give it to the attorney representing that entity. And then if you get denied your FOIL, you'll submit your denial to the same FOIL officer, who will send it back to the same attorney. And in one respect, you'll have an attorney acting as both the FOIL intake officer and then the FOIL appeal officer. He'll be checking his own work. Is that permissible?
I'm assuming that you're not talking about the attorney, him or herself, cannot act as both records access officer and FOIL appeals officer, but both of those public employees have the right to consult with their legal counsel.
No, I get that, but I feel as though that the way the FOIL law is constructed, it should be a different attorney reviewing the work of the first opinion, or am I wrong about that?
There's nothing in the law that would require that, no.
Oh, okay. Okay, I learned something. Okay, I'll defer to the next person who has a question for you.
All right.
Am I muting, or do you have to mute me?
Sorry, sometimes Jeffrey, did you have a question?
No, I did not.
Okay. Sometimes I don't know if maybe hands are just not going down again. So for example, I'm gonna unmute. Kristen, I don't know if you had another question or if your hand just didn't go down.
Oh.
Okay.
Sorry, it was just still up.
I just wanted to make sure you didn't have another question. So I'm gonna go to Mike. Mike, do you have a question?
Hi, can you guys hear me?
Yes.
Okay, so for the last 9 months or so, our town website has been virtually non-functioning. All that you can really see is the phone number for town hall. It doesn't even have the emails up for the town officers. And this has been brought to the town board's attention several times. And twice they were kind of told that they should go to uniform emails, but they're currently all using their own personal emails. Is it possible to foil something between, say, two of the board members if they're all using their own personal emails?
Yes, so if a government employee or official is using a private email address to conduct public business, those communications are records subject to rights of access under the Freedom of Information Law. They may be exempt as intra-agency or interagency material if the communications are between or among board members, or between, like, for example, the town clerk and the town supervisor, or town clerk and the town board. They're, to a large extent, they're probably going to be exempt as intra-agency material, but regardless of whether they're using a government issued email account or whether they're using their own private personal email accounts, if they're using those emails to conduct public business, to government business, then they are those are records subject to rights of access under FOIL. All right, I'm gonna go back to the chat and see. Sorry, I just need to scroll through. Oh, sorry, just opened up an email by accident. Someone has asked if I can speak to constructive denials when an agency repeatedly fails to provide written denials and defaults to reliance on expiration of time limits. I mean, I think we already talked about that and what your rights are. When an agency fails to respond to a request within the time limit set forth in statute, your right is to file an appeal. Another question is, does an agency have the right to require mandatory use of their FOIL portal? No, it's almost similar to requiring them, an agency requiring you to use their own form. Instead of using the FOIL portal, you should be able to mail a letter, or if the records access officer has an email address, you should be able to send the request via email. Another question, how does FOIL speak to verbal instructions from legal advisor to recipient parties that is not subject? Sorry, it is not subject to FOIL, but the explanation for denial is never made in writing to the FOIL. I don't really understand this question, Lori, so if you want to follow up with me directly. I mean, you're talking about verbal instructions. Verbal instructions are not subject to FOIL. Records are subject to FOIL. Does FOIL require disclosure of statistical documents created in political caucus meetings? If the records are not maintained by, with, or for the government agency, then they're not subject to FOIL. If they're maintained for a political party and not for a government agency, then they're not subject to FOIL. Oh, sorry, Mike, I'm going to go back to you here. You said you had a follow-up question. Go ahead, Mike.
Oh, yeah, no, that's okay. So in an email to the town clerk, who's the records person, I requested the emails of the 5 board members so that I could write them a letter. And I got back saying that she only had 2 emails, which she provided, and that the town recognized the need to get standardized emails, and please be patient while that was happening. And it's been going on for months. Is there any, at this point, is there any like way to compel them? They've got like plenty of money to put up a website, but they're just not doing it.
Right
Is there
now,
any
the law
way to,
doesn't
like,
require it.
Yeah.
So
Now,
yeah, the
once
law
they have
doesn't,
the
I mean, it's
webpage,
not required by the Freedom of Information Law. It's only required by the Open Meetings Law if they're taking advantage of the new extraordinary circumstances video conferencing provision that allows municipalities to allow some of its members to participate via video conferencing from private locations under extraordinary circumstances. Under those circumstances, if a municipality has adopted a local law allowing for that extraordinary circumstances video conferencing, then they're required to have a website, but that's the only reference to requiring websites for municipalities in either the Freedom of Information Law or the Open Meetings Law. And the clerk's not necessarily required to answer your question as to what their emails are. But if you requested copies of emails and one of those board members has emailed the town clerk, even if they redact the body of the email, they should share the heading of the email, which would contain the person's email address. Even if it's if they're using that private email to conduct public business, it should end up being available. Another question is, do police reports or documents on a crime need to be publicly filed in order to share it under FOIL? I'm not sure what that means, to be perfectly honest. I mean, if a record is maintained by a police department, then it's a record subject to FOIL. Not sure what it means by publicly filed. If you're talking about filed with the courts, no. If the police department maintains an incident report, then it's a record subject to FOIL. Let's see. This is a good question. Someone, Jeffrey has asked whether appeals are required to be accepted via email. And from a statutory perspective, the answer is no. I think it's kind of silly that agencies refuse sometimes, and they do. There are agencies that refuse to accept appeals via email, and they're not statutorily obligated to do that. It might be something we might want to look to in terms of amending the statute. But at this point, there's not a statutory obligation that they accept appeals via email. I just certainly, if anyone was asking for my opinion, I think they should. Someone asked, is an agency or allowed to remove the website completely? There's no obligation for an agency to maintain, or a public body to maintain a website, except in the description, the situation we just described a few minutes ago. Lori's asking about possible legislative changes for the FOIL law to be ever given. Is there a path forward for New York State FOIL law to be ever given enforcement authority? Again, I don't quite understand that question. There is enforcement within the New York State FOIL law. It's to the courts. If you're asking is there a path forward for the New York State FOIL law to give the Committee on Open Government enforcement authority, it would be legislative. The change would need to be made legislative. That would be the path forward. On my system, I've got Christopher and Mike with hands up. Not sure if they actually want me to call on them, and I'm happy to do so if they do, or if it's just that their hands never went down. So Chris, I'm going to check with you. Chris,
Can you hear me?
Yes, go ahead.
Oh, I was going to just text this in, based on the other questions. Like, is a police blotter or the license plate reader camera image of license plates available in the FOIL?
Police blotter, yes. License plate readers, no. There's a provision under FOIL that references provisions of the vehicle and traffic law that says no, you can't obtain that information through the license plate readers.
Is that because of who retains the record or another reason?
It's just there's a provision in both FOIL that references a provision of the vehicle and traffic law that says that information does not need to be disclosed.
Okay.
I don't know what the rationale is. I just know that that's what exists.
Okay, thank you.
Sure. All right, I don't think we have any other, I'm sorry, Alberto. I'm gonna unmute Alberto.
Hello, can you hear me?
Yes.
Oh, hi, thank you. I just had a quick question about FOILs and certain documents. Hypothetically, say for example, if a private and public entity are working with each other and they share records with each other on related matter, if the private entity if we FOIL for the private entity and they are redacted, and a public entity has access to those records and they aren't redacted, in terms of if you're doing an investigation into some specific matter, but the private entity requests that the public entity redact them after they had been shared or foiled, is that a violation, or is that something you can address? I know it's a really interesting question. I was just kind of thinking about that because, private and public entities do go back and forth a lot depending on the field or the industry sometimes. So I was just curious.
Apologies, I don't think I understand the question.
I think the question was, it basically, if a private and public entity share records with each other and you foil for one that had been redacted and you foiled for the other but it had not been redacted, but the private entity had requested you redact them after, is that a violation or no?
Yeah, I'm still not getting you. So you make a freedom of information, if access, FOIL governs access to the record maintained by the public entity.
Mhm. Yes.
If they maintain an unredacted version of the record,
Mhm.
they would need to review it to determine rights of access.
Okay.
One of the permissible grounds for redacting a document is information which maybe contains trade secrets or information which, if disclosed, could cause substantial commercial injury to a private entity. And the private entity can request that that information be withheld, but ultimately it's the public agency's obligation to make a decision as to whether that record gets redacted or withheld.
Mhm. Okay. Thank you. I think I understand you. I'm sorry I didn't phrase it
No,
correctly,
that's okay.
but I think I
No worries.
understand it. Thank you so much.
Okay. All right, I'm gonna take one more question here. Lori again asked, how does someone deal with an agency's failure to maintain records per the New York State record retention requirements? That's not governed by FOIL. Record retention schedules and oversight of that is done by the New York State Archives. So I'm glad we had a small group today. Normally I don't get to interact using actually hearing people. Usually I've got too much of a large group to do that, but it was a nice size today. So I thought I would do things a little bit differently. So I'm glad we got to do that. Thank you, everybody, for joining me today. Again, if you ever have any follow-up questions, you're welcome to contact our office. And I hope everybody has a great day and a good, happy new year. Thank you very much.